Board of Adjustment meetings are being held in person, meeting hall, on the second floor of Borough Bowling. At 166 Minot Road, members of the public who should offer commentary or questions required to attend meetings in person. Notice the changes and also emailed with Borough News, Courier News. By posting copies of the open board, Borough Hall, Borough website, by filing copies of the clerk, all on March 13th, 2024. See attention board not in any matter past 11 p.m. Any regular or special meeting of the board unless the motion passed and members are present will extend to later specified cutoff time. And same shall be announced to each meeting. Members of the public may participate in meetings certain times of the announcement of the chair. Members of the public will be permitted to address applicants and their experts, ask questions, and make comments as appropriate once invited to do so. Any hearing conducted by the board is a quasi judicial proceeding. Any questions or comments will be limited to issues that are relevant to what the board will legally consider. Reaching a decision to form appropriate to the judicial hearing must be maintained at all times. Roll call, please.
Yes, Mr. Chairman. Apologies. Mr. Delarusso.
Here.
Mr. Greenbaum.
Here.
Ms. Kramer. Here. Ms. Leffler. Is absent. Mr. McDowell.
Here.
Mr. Malillo.
Here.
Mr. Salyer.
Here.
Mr. Slocum.
Here.
And Mr. Trainer.
Here.
You have a quorum, Mr. Chairman.
Thank you. Okay, so we have meeting minutes from August 5th. Are there any additions or corrections?
I'll make a motion to approve the minutes.
Is there a second?
Second.
All in favor?
All right.
Opposed? Minutes are approved. Okay, communications. Two things. We have a planner. Here's the plan. Always good to read. And we have a letter from attorney for Liberty Farm Dog, which is attached to the resolution that we are not memorial. So the applicant has requested us to remove the application. Terminate the approval. Terminate the approval. We approved it at a meeting, but the applicant has asked us to terminate that approval. So I am going to read that in under old business here. Whereas the application for use variance approval has previously been filed by Liberty Farm Dogs LLC. Hereinafter designated the applicant to the Borough of Bernardsville Zoning Board of Adjustment, hereinafter designated the board for a property located at 21 Liberty Road, Bernardsville, New Jersey, more specifically known as Block 113, Lot 13, on the tax map of Borough of Bernardsville, hereinafter designated the Borough of New Jersey, with said use being not permitted in the R5 zone. And whereas a public hearing was held before the board on December 4th and March 4th, 2024, December 4th, 23, March 4th, 24, with regard to this application, and whereas the board heard the testimony and evidence presented by the applicant, witnesses, consultants, and with public having had a full opportunity to participate, and whereas at the conclusion of the hearing, the board voted to approve the application with conditions, and whereas subsequent to approval, the board, through its administrative officer, Gallardo, received a correspondence dated June 3rd, 2024, from the attorney for the applicant, a copy of which has been attached here to and incorporated herein. And whereas the June 3rd letter indicated that the applicant was now precluded from proceeding with the approval for the property and therefore needed to abandon said approval. The letter also indicated that the applicant understood that by abandoning the approval will now become null and void, and that the applicant would not be legally able to proceed with the use of the property as previously approved. Now therefore be resolved, the zoning board of adjustment for Bernardsville, County of Somerset, State of New Jersey, and based on 16th day of September 2024, made the following conclusion concerning approval. One, based upon the attached correspondence, the attorney dated June 3rd, 2024, the board has determined that the prior approval granted to the applicant by the board shall hereby be terminated and be of no further force or effect. The approval has been deemed abandoned, null and void, and the property that had been the subject of this application shall no longer have the benefit of the prior approval. Anybody have any questions on this? Yeah.
I assume you're not doing it, you're not having anything that's, right?
Well, they're not allowed to have any that. They're not allowed to have the farm law business, daycare business running at the site.
I'll make a motion to approve.
Second. Roll call, please. And I think it's probably other people that were here. for the
Yes.
approval. Okay,
So, Mr. Del Russo,
yes.
Mr. Greenbaum,
Yes.
Ms. Kramer,
Yes.
Mr. McDowell,
Yes.
Mr. Sallier,
Yes.
Mr. Slocum,
Yes.
and Mr. Malillo.
Yes.
Motion carries.
Okay, and on the agenda here, it's only Del Russo, Greenbaum, Kramer, Snyder, and Malillo.
Yes, I made a mistake. One of the board members brought it to my attention and I redid it, and that's why I read from my sheet here.
Okay, good, okay,
I left two names off there.
cool, that's fine, thank you.
Thank you.
Okay, so now we go on to the application. It's dated for the Rushman, Meadow Farm, 259 Road. Who's here to represent that application?
Yes, Mr. Chairman, my name is Susan Rubright. I'm an attorney with Brock Eichler in Roseland, New Jersey, and I am here tonight on behalf of the estate of Bertha E. Rushman. Okay. So first I'd like to just give a little description about the property, and I know we have to go through completeness. One thing I would like, sure.
Oh, yeah, the notice of publication.
Yes.
I know we have to go through Mr. Brightly's report for completeness. I do have an introduction, which I think will help address some of the issues that Mr. Brightly cites in the completeness letter. So I would like to go ahead and do that if the chair would permit that.
I think we need to go through the completeness first.
That's certainly your choice. That's certainly your choice.
Because without that, we can't do the application.
Well, there's some and I appreciate that. There are some certain items that we are asking for waivers for completeness purposes only. And there are some factual issues that I want, factual items that I wanted to bring to the board's attention that would help support the request for the completeness waivers. For instance, if I might, while the application is styled as a subdivision with variances, I want to repeat that there's nothing that's going to be developed here. So a number of the waivers for completeness purposes that we're asking for will go then into more detail with the testimony as to why we're asking for
Let's
waivers
discuss
for
that.
that.
Each one of the items for completeness.
I'm sorry.
Let's discuss that with each
I
one
see,
of the items.
fine,
for
that's
completeness.
fine, appreciate it, okay. So I do have our site engineer, Richard Schomer from H2M, who can discuss, I guess, some of the issues as well.
Then you need one, and he's gonna.
Yes.
Raise your right hand, please, with regard to this matter. Do you swear the testimony you're about to give shall be the truth? So,
I do,
could you state your name, spell your last name, please?
sure. Richard Schomer, last name Schommmer.
And you've been in front of this board before and qualified as an engineer?
I have, it's been a while, I'm trying to remember the last application, but it was, over the past 40 years, I've been before this board a number of times, but I'm happy to proceed if you like.
If you wants Mr. Schultz to qualify himself, that's fine, but it's been around the block.
Your license is still,
Current and active, yes.
okay. Thank you.
Thank you.
So the first one here, checklist requirements. The subdivision applications are required to provide the following information under the section, location of all structures, including buildings, et cetera, within 300 feet of the subject property. And this was, I'm looking on John's report, John's able. Yep,
Yeah,
item B.
okay, so let me,
Just, make
yes.
this- I think if you can just go through and cite the number of the comment, and then the letter, and then the number as well, because I'm not sure that it's being picked up, and this is being recorded, so I would ask everybody to keep your voices up, including Rusty and the professionals. But yeah, just indicate what it is that you're referring to and responding to.
Sure. So, and I did a response letter to the board dated August 27th, 2024. And basically reiterated the comments in Mr. Brightly's review memo, review letter dated June 19th. And then I went through Mr. Zabel's review letter. He did issue a subsequent review memo, or I think ours kind of crossed in the mail almost, but so I think the first one you're really referring to, and it's item 6 in Mr. Brightly's letter, and this is under the review checklists for concept plan.
I'm actually referring to Mr. Zabel's letter, not Mr. Brightman's letter.
Okay,
Wait, Mr. Chairman, you may, since our reviews kind of coincide, I would suggest that we work off of Mr. Brightman's report, because they actually cover everything, including checklists, and he opines on some of the engineering aspects of this, so I think it would be appropriate to defer to his review, even though we kind of share that responsibility and I covered much what he did. He has certain issues and questions. And this is important because there are two aspects in this application, if I might, to frame it for you. There's the use variance aspect of this. The applicant for the board for the use variance of the Raspberry case, where the courts have issued a determination that when there's a subdivision that reduces the size of a non-conforming use, that it requires a use variance, it's an intensification. However, this is a D1. The reason it's a D1, which is the higher Medici standard, is simply because this use, the glitter factory, is associated with the use variance that was granted as far back as 1959. It doesn't meet the definition of the pre-existing non-conforming use for a D2 kind of application. And I think the applicant is aware of that and will address that. So there's the use aspect, and whether or not the board feels that the reduction in the size of the property impacts that factory in such a way that it's no longer viable or can continue to operate as it did in the past. That's one aspect. The second aspect, the responsibility of the board, is to review the subdivision against the major subdivision standards of the borough. And the main issue is under section 10.8, 10-8.1, the lots have to be viable. That ties to Mr. Brightly and my review in terms of what information is required or should be presented to the board. The board will need to determine what they're comfortable with in order to make that determination as to the viability of these properties. But the last thing you want to create, because there's still here the board of adjustment, but you also plan is looking ahead. You want to make sure that the lots are suitable to people. And that burden will be on the applicant. I'm sure the engineering and the planner will address those issues as well. But it ties to completeness. And Mr. Brightly had issued a letter that expressed some concerns. And my recommendation is always to grant waivers, but always with the concurrence of the board engineer, because there may be things that I don't think he need, but he may. So I just wanted to provide that little context.
Okay, thank you. Okay.
And we'll start on page 4.
Okay.
Page 4 of your report, Mr. Brightly, or the response
Yeah,
letter?
I would look at Mr. Brightly.
Okay.
He's got the same.
Starting with 6A1, it's the same point.
Right, okay.
yes.
It's also what. Yeah.
Okay. Gotcha.
Right.
So we're all on the same page.
Right, okay. And let me just, in terms of context, I know everybody's trying to put some context. The waivers we're seeking are for completeness only. Well, if during the course of the discussion and hearing, the board says, we'd like more information on that, that's fine. We'll seek to give you that information. So it's not, we're really hoping to be able to get past the checklist waivers so we can proceed with the discussion of the application. And I think when you hear more, you'll understand better, again, the context of the application. I know what Mrs. Rubright was gonna say with respect to the application in terms of, there's no development proposed with this subdivision. Now, we're carving the property up into some new lots, but we're not proposing a typical, we're here to seek a subdivision to build on each of these lots, to build new homes. That's not what the applicant is here for. The applicant is here to satisfy the requirements of a will and settle the estate. There are three, and Ms. Rubright can tell you this, and I think probably where she wanted to go in her opening comments, but there are three beneficiaries of the estate, and the objective, and the only reason this application has been filed is to settle that estate. So we're simply trying to carve up the lots, and I probably shouldn't use the word carve up, but subdivide it to create lots so that each of the beneficiaries can settle this estate and move on. I know that from the prior applications and approvals that were issued specifically for the glitter factory, we'll talk more about the glitter factory, but the industrial use on the property, that there were limitations imposed, that you couldn't subdivide the property further, you couldn't develop the property further, so long as the glitter factory stayed there. That's fine. The applicant is fine with that. We're fine with that. We're not seeking to change any of that. We're not seeking to build over here while keeping the glitter factory over there. Again, no change is proposed. We're not seeking to have any development or build something on any of the lots. This is, again, the sole objective, and the only reason this application was filed was to settle this estate. So I think that context is important to keep in mind. Along those lines, so because we're not seeking to build anything, not seeking approval to construct anything now or for the foreseeable future, the applicant's willing to impose conditions so that the board and the borough is comfortable in maintaining the status quo. The objective is to maintain the status quo in terms of uses and activities on this site. There's a glitter factory, there's a farm, there's some residential uses. All of those are proposed to stay as is, no change. There's large farmland areas. Those are proposed to stay as is, no change. So as we go through this and we talk about some of the waivers that we're seeking, I think we want to keep that in mind. The applicant's not saying, well, I want to build here while keeping this over here. The applicant would like to keep everything just the way it is. But there's a mandate, and Ms. Rubright can address it much better than I can, a mandate with respect to settling this estate, which has been, I'll say, open for some period of, I think 2009 or something like that. So that's really the objective here. And we'll talk, and you'll hear us tell you that several times probably, but that's one of the driving forces behind why we didn't want to go through and why we're seeking waivers for doing some of the stuff that otherwise I'd be in Bob Brightly's camp. If we were coming in to say we want to build lots on these, I'd say, yeah, we should be doing these things. I would tell the applicant, we ought to be doing these things. But because of the nature of this application, because of the purpose and the goals and the objectives, the only reason why we're here, we thought, let's seek waivers so that we can move on, get the estate settled. Again, we're not seeking to try to get away without doing something. If during the course of this discussion, the board says, I'd like more information on that, we'll seek to do that. And before anything could get built on any of these lots, all of this work would have to be done, but we don't know when that might take place. And so one of the things we've said, and we'll go through each of the, I'm happy to go through each of the waivers individually, but this, the reason I'm giving you this explanation is because I think it applies to many of them. If we were to seek, do a hard wetlands delineation, for example, now, well, those have limited lifespans. They're gonna expire, and wetlands it could change over time. So doing that now and having that locked in, when nothing is gonna happen and the LOI is likely to expire, for example, and wetlands may change in the future, we don't really see the value in that. You'll see that the lots are all way oversized compared to what the zoning requirement is. And that's again, simply because we're trying to create specific parcels to go to the beneficiaries of the estate. That's again, that's why we're here. Rules change over time, so we can try to do something now that might say, okay, let's meet the current rules on demonstrating something. But those rules might change. And again, we're not seeking to build anything now. Whenever anybody might ever come to seek to build anything on the property, those studies, those investigations, those proofs will have to be made. So that's kind of a little bit of a, again, in context of the application and some of the reasoning why we're seeking many of these waivers. I'm happy to go through them. I mean, we'll go through them, but I think as we talk about many of these and this is starting with this first one that we were just looking at. There's going to be no impacts from developing this site, because that's not what is proposed. Usually with a subdivision, I'm going to be up here talking about the roadway and the drainage and things like that. None of that applies in this case, because even though we're going to create a lot, those lots can't be built so long as, say, the glitter factory stays in place. Again, that was a restriction that was placed on the property. We're not seeking to take that away. We're not seeking to change that. So to the extent we can provide the board with some comfort as to that, and so you're satisfied that, okay, you're not trying to do something without doing something else. We want to try to do what we can to make the board comfortable, and to the extent we can work together towards appropriate conditions that the applicant is, and I'll speak for Mr. Bright, but that the applicant is absolutely willing to do that. So I'll leave it there, Mr. Chairman and board members, and happy to go through these individually and in more detail as much as you like.
Well, before you step away,
Just
okay. My concern is that what this board does has to do with lots and their future use, and whatever this board does, that sets boundaries, guidelines, whatever, for future use of pieces of land. And when you say nothing's going to be done, so we don't need to do these bits, I have great concern. So my comment is, would the applicant be willing to accept a condition that says nothing can be done?
until this.
So nothing can be done.
So-
If you want to be able to do something in the future, you have to answer the board's questions today.
So,
Otherwise, we can't act.
yeah, Mr. Chairman, if I'd like a little clarification on the question, and then also just to represent on behalf of the applicant, which is the estate. And I appreciate Mr. Schomer's summary. It is part of what I was going to discuss, so that's helpful to give the context. The lots are very large, and we fully accept and understand the condition that has been imposed on this property since 1957, when Mr. Rushman appeared before the board at that time and was not able to, and was looking to have the glitter factory use, put glitter factory in quote marks, in order to help supplement the income and sustain the ability of the farm to remain, and that's all in the resolutions. This isn't, me saying so, it's in the prior resolutions. The reason why the property has been able to remain the pastoral scene that we all love is because of the glitter factory. And that's why, because it was a viable use and it remains a viable use. So we are fully willing and advocating to accept the condition that if there was going to be any further development of the lots that have to be created in order to complete and finalize the administration of the estate, that condition would be that there could be no further subdivision of the lots that are being created that were originally burdened by the condition that there could be no subdivision while the factory was operable. We are perfectly willing to accept that condition. We offer that condition. It's not an unreasonable condition. So, for instance, some of these lots are 34 acres. This is a 3-acre zone. The reason why this is happening, as Mr. Schomer indicated, is that Mrs. Rushman in her will set forth the general parameters for deeding or providing the lots, the parcels for her 3 heirs, her 3 children. And the allocation was done such that the parcels were divided based on where the family members were living at the time or near. For instance, one of them, two of the heirs live on the property currently. One lives adjacent to the property. Those are the 3 general divisions, and the lots were created to in an equal value as possible, so that the heirs could be deeded that property. The reason why there's 8 lots is because the railroad runs through the middle of this property, and I went to high school and I took the train and went on that train line. As I'm sure a lot of people know people that did that as well. So yes, and I'm really that old. So you did it too. You still ride, so you've been through the property. But that's the reason why there's 8 lots and 1 lot, and we will talk about the factory, why it's on that lot. We wanted to keep as much of the pasture land available as possible. So it went from the entirety of lot 2, which is 150 something acres, down to 6.5, because we wanted to keep it concise and have as much area as possible still devoted to the pasture land, to continue the pastoral views that we all enjoy. So when you say, this is all getting to your question, to your condition, when you say you can never develop this property, I think that that's a little bit beyond the ken of what the board can dictate at this point, but certainly we do not want to change anything. The heirs, to my understanding, do not want to change anything that's going on this property. They love this property. They grew up on this property. And to require us to go into do a lot of invasive testing and expensive testing when there's going to be a condition that the property cannot be further subdivided while the factory is in business, is I think, I would submit to you, is reasonable assurances that we're not going, that nothing will happen to this property unless someone comes back to this board and does all of the tests that you're requesting, or that Mr. Brightly has brought to your attention.
So when you say you divided the property up in relatively equal values, how did you come up with those values if you don't know how the property can be developed forward?
Good question, and I think Mr. Schomer can address can address that, because we did spend a lot of time trying to achieve equal value. And I would also indicate that there are other properties that are part of the whole equal distribution valuation, but with regard to this specific property, I'll let Rusty discuss how that was done.
Sure. So we did look at, is it helpful to maybe look at a plan?
I think it would be good.
Yes.
Yeah, let's.
So these issues involving property have been around for approximately 15 years. You mentioned, I think, Ms. Rutland died in 2009.
Yes,
Okay,
yes, she was her husband predeceased her and she passed away, I think, in 2009. 2009.
okay. In that time, has there been any? Keeping in mind, this is land use board, and we're not in chancery where we're weighing siblings issues. Okay.
Right.
Is there any litigation that we need to be aware of involving this family? That would impact what we do? I haven't seen
No.
anything.
Not to my knowledge,
Okay.
no, there's no litigation.
Okay, all right. And that's all I have for that.
I have a question. Is it in the board's power to get involved, I mean, the main purpose is to settle with the state, is that our job?
Our job is to consider a subdivision like any other subdivision application. This happens to have ancillary issue involving siblings. But we need to look at this as the court differentiated as a straight subdivision. We would handle, and with variances, with a use variance, and we handle it and consider it like any other similar application. I mean, we're not here to make everybody ecstatic, if that's ever possible, but we're here to consider this a land use application.
Yeah, and it has, whatever we do has future implications. And that's what I'm concerned about.
Mr. Chairman and Mr. Rego, I would just like to supplement the response to the board member's question. The reason why we raise that is in support of the fact of why we need to subdivide, which is technically in violation of the condition in connection with the factory. So what we're saying is that we need to do this. It's like two different interests, but we need to do this to wrap up the estate, but then it violates the prior condition of having no further subdivision while the factory is in business. So what we're agreeing to, of course, is that if the board grants the it's part of the rationale for why we need the subdivision, basically, is that we need to wrap up the estate. And we are agreeing that we would condition any approval on no further subdivisions being required unless the factory goes away, and we would have to come back here as well for further subdivision.
Just another, I've not seen the will. I don't know if we need to, but is there a condition in the will that says there can be no subdivision? I thought I read that somewhere, as long as the motor tractor is in operation. If there is, before we look at this, do you need to go to court to allow that?
So I understand the question. There is nothing in the will. I mean, I'm not the estate attorney, but the will sets forth the general parameters of where upon her passing, that the distribution is to go to the three heirs and in the approximate location of where each of the three live or live near and take care of, by the way, as well. There's certain, there's the one certain property that fronts where a lot of the cattle are that front along the Quarry Road, and that child, even though they're all adults, is being devised that because he takes care of that property, he lives on that property. It's a general allocation that we then had to
Right, but
take.
can we, does the will say that the property as it is now, 215 acres, which is a big piece of property, does it say that it cannot be subdivided legally unless and until the litter factory goes out of
No,
business?
it does not say that. It's not in the, not to my knowledge, and I have reviewed those relevant sections. Correct.
I have a question, to Boo, I think. Is there a way to essentially bifurcate this application to hear what really is the crux of the matter, which is the rationale for why they're subdividing? We're starting to talk about it already. which is sort of, what does the will say? Is that a legitimate reason? You know, to support, you know, the variances that they're requesting. And deal with that issue first, before we spend a ton of time dealing with a lot of engineering issues. And I think the engineer makes a good point about wetlands, you know, do we need to consider it or not? It almost seems like that would be, like, once we deal with the issue of whether this should even move forward from a legal standpoint around whether there's a legitimate rationale.
Okay, what is completeness? That's where I'm trying to get to.
Yeah, is there a way you could sort of say, we're gonna like hold on completeness from the subdivision standpoint and deal with essentially the use variance first, and then.
Which is why I was asking about further development, because we don't have enough. We don't have enough information to really talk to the
Right.
lots.
Yeah, so can we deal with that
Because all of
first?
this stuff is missing, so how do we handle that with conditions or restrictions on the property? And if there's a decent way to do that, then we can grant waivers for the missing elements. And that's that's the path I was trying to go down.
Right.
Quick question, let me respond, certain, Rich, and I asked John to chime in too. The land use law allows an applicant, I don't know if we can force it, but it allows an applicant to say, I'm gonna split this, let's deal with the use first. And the subdivision, all that second, but. I mean, they're not developing anything here, so I'm wondering what the second part would be, other than here are the lines that we're proposing. What I don't wanna do, and I know you mentioned the will, but I don't think this board wants to, and if you don't agree with me, fine.
Do we even care about will?
No, and my point is, I don't wanna know what the will says. I'm told this property is just to be divvied up 3 ways. We can't deal with how much one's worth as opposed to the other. We're looking at this in land, here it is. And I can understand if nothing's being, if this was a lot being developed, I think we'd probably be here for a year to, hearing this thing. But it's not, so I think, and I understand the chairman here, we wanna know what. Is there gonna be another card being turned over here? We don't know that. Whatever's turned over here has to come back here anyway. I mean, if we.
We need to make sure that the resolution states that, and that the
Yeah,
applicant
clearly.
accepts that condition in the resolution.
There's a subdivision here, three lots. And then you're talking about 8 lots, it's a lot of moving parts here. If the board ultimately decides to grant the relief, we're not gonna do it based on who's happy and who's not happy, and who wants another acre, who doesn't want another acre. This is the plan. If the plan gets revised, wonderful. If all the siblings get together and do whatever they have to do to be happy, and you revise the plan and come back and everybody's happy, but we're looking at the lines on the plan, and we're looking on, at our experts' reports. And what we don't need to know, as Ed said, the will is not our concern. This is a straight, no, maybe not so straight subdivision application without development at this point, without any changing on this point, other than putting lines on the lots and the lines on the plan. And as long as everybody knows, as the chairman said, other than that, we're not going any further. I mean, if anyone wants to develop this or build on it, you have to approach it like any other land use applicant in Bernardsville. That's what we consider. We're not, you just can't get a subdivision and go off and build something. You gotta follow the process. You know that, Susan.
40 years.
Yeah, so.
39
And the chairman wanted to make sure that was clear, that we're here
Yeah.
to, again, I don't personally care about a will. I just want to know if there's any litigation that
There's no
involved us, which I've not heard of. So, other than that, I'll leave it, the best way to proceed without wasting, right now, contour lines and all this and dry wells, it just, what can we focus on to get this moving?
Can I just ask one question? I've heard this a couple times, that if the glitter factory was to go away, that they have to come back to the board, and for what reason?
No, let me try to clarify. The condition of the approval and the condition in the several resolutions of approval that were drafted by older iterations of this board state that the property cannot be subdivided any further, or could not be subdivided if, and if it were, then the glitter factory could not operate any longer. That's the connection, and you're looking at me, I don't think
Yeah, I
I'm
don't
clear.
answer the question. What I understood you to say that if the glitter factory use,
Right,
it's abandoned, then you'd have to return to the board to do any other development.
no, that's not what I said, and if I said that,
Creating.
Further subdivision. she said.
right, further, meaning, okay, no, good question, okay, so let me clarify that, so what we're seeking to do, and can we put this up, because I think this would really help if we could put this up visually, we are seeking to subdivide lot 2, which was the prohibition in all of the prior resolutions. We're seeking to do that because we need to subdivide in order to devise the property according to the will. So what we're saying is that we would agree that we would not, so there's one lot, I think it's 34 acres. If someone came in and wanted to subdivide that property into 3 acre lots,
10 lots.
10 lots,
And they got-
then they would have to obviously come back to this board, but the glitter factory would cease to exist. So that's, that's what the connection
That's
is.
not, this application is.
That's not this application.
So,
Right.
the way I see it, what I'm hearing, is that we divide this up into 8 lots. Conceivably, somebody could put up a single house on each one of those lots, because it is residential.
Correct.
And they would not need to come before this board to do that. They just go get their building permit, because obviously they have an adequate size lot circle, whatever.
And that we do show that on the plan, but obviously they would need to get all of the other,
If you wanna subdivide, then the only time the subdivision could occur, a subdivision application could occur, is once the glitter factory ceases to exist.
Correct.
I don't think the subdivision application causes the glitter factory to cease to exist. I think the glitter factory has to cease to exist before a subdivision application could be made.
On any
Now-
of the lots.
And once the glitter factory ceases to exist, there are 6, 8 lots, whatever the number is, and those would go before the planning board, not the Board of Adjustment, in order to be subdivided. I think that's what I'm hearing. I just like some clarification from the lawyers.
I like what kind of variances are they asking?
They're gonna go through they need a use variance, and there's dimensional variances. No, well, not building anything, but there's existing structures that require certain.
Setback.
Which they'll go through.
Setbacks because we're creating new lot lines,
Yeah.
as an example.
There's nothing.
But
I can.
Ms. Ruth, right, it was my pontification accurate.
yes, without confirming that it's pontification. This is great, okay, this I think will be really helpful.
I simply don't wanna go through the evidence right now, no.
Okay, understood, no, but I think this would be helpful to show, and do you have the other one that shows that? So one,
Hold it, just
Mark,
Yes, like, 2 questions. One is when, they are saying that the glitter factory goes away, does that mean cease to exist? And, or does the building go to the dirt and it becomes, a buildable lot without industrial structures on it anymore? Or does it become a warehouse or an Amazon or something of that nature? That's my question.
Yeah.
That's my first question. Second question is, I've heard, and plus what I've read, many times this thing is basically based on the will, of course, but that equal value to say twice tonight in the paperwork, it's equal value. But I'm struggling with, how could you, mine happens to be on the floor, but how can an appraiser appraise those blue lines for equal value, if in fact, he doesn't know where the wetlands are, he doesn't know where the slopes are, he doesn't know where the.
Fine.
Yes, I.
That one is not our concern. Equal value is something for the estate lawyer to take care of.
Yeah.
I don't wanna talk about equal value.
Okay.
We already land use for it,
And again, that's.
and we don't establish the value.
They can put the line there.
They can put the line where they want. The, but you bring up a really good point.
Yeah.
With the glitter factory.
Even
And
if the glitter factory.
if the glitter only was written as a
2%,
well,
and the building was operating in just 2%, and we rented the rest out to Amazon, that's the same concept.
the resolution from 1950, whatever, was written to the glitter factory. But, oh, by the way, at this point, it really ought to be any commercial concern on that piece of property. Not just the glitter factory.
I think it was very interesting as a land use attorney for below these many years and a planner prior to that, to see the conciseness and short. I don't know if this is the correct way to say it, but the shortness of the resolutions compared to what a lot of resolutions and the way boards think today. The resolutions were not that long.
Their recommendations.
They were actually recommendations that went to before we got the MLUL in 1975. Those are conditions that the board could posit, because it's not stated, it just says the glitter factory.
But I think their simplicity work if you look at the overall picture.
Right.
Whereas this is a farm, and to supplement my income, I'll keep this pastoral as long as I can operate this commercial, as I guess you testified too. That'll supplement. But again, once that goes away, then it becomes a minimum of 8 houses, could be 50 houses, that's a whole different.
Well, it's-
situation.
What I think, Mark, what I think is important is that the glitter factory becomes, in definition, a commercial concern.
Right. That's
So I don't want to tie to just the glitter factory. I would like
any commercial.
commercial concern that there's no subdivision as long as the commercial concern still exists.
And Chairman,
Exactly.
but Mr. Chairman, I don't believe that the use variance that was granted by the borough to the glitter factory would extend to any other. commercial use. It would have to come back.
Yeah, that's true.
You
too.
could word, again,
You're right, John. You're right, absolutely, because it's a residential zone, so if you change the use of that property,
Okay.
we would still have to.
it
come
needs
back.
to be on their,
But I
instead
think,
of asking what they're doing.
Yeah. but I think we can
But it could
make
be
it very
language.
clear by saying any commercial concern.
Right.
Because we're basically starting from scratch, right? Because the subdivision voids the original variance.
It doesn't really void it.
Well, it does, but
It does, because there's a condition that
It's
it
issued.
can't subdivide.
And so part of their application is a whole new variance for
Right.
the existing factory on 6 acres.
It's up to us to pull it in.
Exactly, so then we can define commercial property or,
We needed to clarify these issues. Rather than them coming up 2 months from now, we need to get them on the table so we all know. what we're saying.
Yeah.
No,
Are those the
it's
kinds of
not,
things that would be acceptable to the applicant so that we could move forward? with this?
yes, they would be.
Okay. So. Well, let's go through the rest of the items here that Bob noted. Most of them are.
So Greg, I'm sorry.
Pardon?
No, I was just looking at the waivers, Mr. Chairman. So you want to go through those? Like, take a look at those?
Yeah, well, I'm looking at the other checklist
Okay.
items, which are the things that are site work. Which would all have to be satisfied in order to do a subdivision. As long as there's no subdivision that's allowed, we don't need to do the site work at this point, which is what I think the applicant's posture is.
And given the size of the lots, and we did supplement the plans with some additional information. We showed, for example, the soils information. I can give you information about the slopes and what those slopes are, so that if that helps the board understand the property a little better. So I don't know if you want to go through them briefly, item by item, or.
I'm just looking through the checklist myself, and everything in section 6, if I'm reading it correctly, Bob, item 6, is all really site work that would have to be done for a subdivision.
This is,
Yeah, I know it's subdivision, but if it were to be further subdivided in order to put houses on it, you really need to do this stuff.
well, so, the board's gonna have to make that decision. That the property does contain flood hazard areas, contains wetlands. The bearing buffers, both 300 and 150, and probably a lot, some steep slopes. I think those are the issues. Those go to the, and then whether you can get septic on it, where the wells are, how are these lots gonna be serviced, I think there's 7 wetlands on the property right now, based on prior applications. So where are those septic systems, how are they getting their water, are they crossing property lines, so there's issues, I think.
But what I'm thinking is that if you wanted to put one house on that lot, if it didn't have a house on it already, you would have to pass through Board of Health, you'd have to pass through where the septic gonna be, where's the well gonna be. You couldn't do, if you were violating the steep slopes ordinance, we'd be back here, just to put a house on an empty lot. If that lot already has a house on it, you can't put a second one without coming here. So there's enough, barriers to further develop where all of the things that you're mentioning are terribly important, but would have to be satisfied either by the building inspector, by the health department, by engineering, somebody. And it would get reviewed when you're trying to put a house on a piece of property.
That's true, that's gonna be the decision the board has to make.
Yeah.
Whether some of these lots, you're limited to developing in 1/4, and that's gonna require front yard setback variance, side yard setback. Every act in the board for that.
But we can discuss that when we're looking at the lots. Right now, we're looking at checklist waivers.
Yeah. In the past, the way we've done it was, we'd ask John, we'd ask Bob, here's a checklist, what do you think? And they either said, we need to know it now, or we can go ahead and hear the application, but we always kind of like to ask for more information when the issue comes up. If we're 2 hearings in and we have issues as to floodplains or steep slopes, certainly ask them, but it's just to get over the additional hurdle of completeness, move ahead. So that's where we should be, I think.
So I think that's what item 6 really started discussing. And I think that we might have enough checks and balance in other areas of land use where we could hear it without specifying all of this stuff up front. This is a gut feel, but
Does it make sense to put one, not that I want to, a huge convolution, but at least to memorialize it so that there's an understanding.
well, we either grant the waiver or we don't, so we go through, certainly welcome to go through the waivers.
And it sounds like the applicant is okay with us granting waivers and sort of reserving the right to ask for this information later in the application if we then.
Yeah,
That's the way we normally
So, doesn't seem like a big risk.
Yeah, we agree with that.
and I just wanted to get a feel for the board's ability to hear this application, given all the items that are missing in the application that Bob and John have noted, and I think that they're all important, I really do. But I just want to make sure that we've got the protection we need, so that anything we do will make sense, will be legally binding. It's not gonna get overthrown by the Superior Court.
And that's where I was coming from.
Yeah. We want to make sure that we keep up everything we do, strictly legal. It's a first, that's not for this board is really thinking about that, you know that. I know that, we are probably one of the biggest mistakes, but. Water elevation, state rights of funds. This applies sewage disposal. You can see what they're getting stewards of. They can connect up to the plant. They're pretty disaster.
Do you know if there is some,
But how?
is that sewer?
Oh,
is it in this, I don't know if it's in the sewer surface area.
They're not under social.
It's not yet.
But, you know, sewage also get an easement for that. But, you know, those, that's when you come up with development, site development plan for the subdivision. Then.
You might have to get the resolution, so we know that we can't just pass it. You just show it. Don't make the last, I want my house here, we never protect the slopes, we never protect the streams.
We don't have to protect the slopes, and we don't have to protect the streams, because, oh, by the way, in order to put a house up, you gotta get all the other approvals, so when the building inspector looks at the plans and sees what the slopes are, if you disturb it more than 250 square feet or 30%, it's here. So, I mean, all of those protections are already in the zoning ordinance. Subdivision, close subdivision, a lot, no, it's confirmed by the tax assessor, yep. Preliminary subdivision plat should be revised to reflect the anticipated lot numbering, which, just requires public conversation and the assessor.
We did that.
We did that.
We did that.
Cool. The rest of the rest of your report really isn't dealing with waivers, is it, Bob?
I try to go through the report and identify the variances.
Yeah.
Typically, what we do, there's not a lot of technical comments because there's no development at this time.
Okay. But the variances, the waivers are mainly about the things that will be required for.
The environmental constraints is the main focus of our completeness.
Okay. And as long as the applicant is comfortable with no further subdivision, as long as the commercial concern exists, and any further subdivision would then have to go to either the planning board or two, depending upon what it looks like. Then all of those questions would get answered at that time.
Well, I'm not looking at future subdivision, I'm looking at this subdivision, whether these lots at some point down the road could fit a single family house. Lot 201, it's got floodplains, wetlands, buffers, and it's gonna have an accessory barn on it. Now, where's the access to that lot coming from? Where's the house going to go? Is there a place for it?
Okay, so,
If not,
so-
we're creating a lot that can't be built on.
so does it make sense then to have those items identified during the hearing process?
It's gonna continue to be my recommendation that would at least be an environmental constraint house. You never stated that they need to go get an LOI. But they did get a wetlands expert to approximate where the wetlands are with the buffers.
Okay. Absolutely.
The other information is really there already. It's, they show the buffers are not correct. I mean, they aren't revised plans. They don't have revised plans.
I missed that. Could you repeat that question?
At least on the first. It wasn't really a question. I said they show buffers, but they weren't correct on the original plans. Maybe they corrected them now.
Yeah. The varying zones. you talking about.
Very zone.
Yeah, no, we did. That's in my response letter in the plans, the
Yeah, I don't
latest
have the
plans.
plans, so I'm not sure. I've been away.
Oh, okay, all right, fine. I mean, is it-
Other application out.
Oh, okay.
Okay. So during the course of the hearing, if you find that the information that's being presented remains incorrect, is it acceptable to have it be corrected before the?
Yeah, I mean, it's fine,
Okay.
it's on the plans. I think the board has a better understanding that these large lots can easily accommodate a five-bedroom home.
Okay,
You know, not a little accessory apartment above the garage.
so questions of the board. Are you comfortable with granting the waivers that the applicant has requested? Do you feel we've covered the issues enough that during the course of the hearing, if there's something you're uncomfortable with, we can ask for more information?
That's what we.
That's a question of the board.
What did you say, Rich?
If we grant waivers for any application, we always reserve the right, the applicant's agreement,
Yeah.
to ask questions down the road. If we didn't think of something in the front and something rears its head, we can ask for something, traffic, environmental, that maybe wasn't obvious in the beginning, but it pops up now, and we certainly reserve the right. So if you grant waivers and move ahead and know that if we get stuck on something, we can get the information from them. And I'm assuming Susan.
Yes, absolutely, we agree.
Agree.
That's standard, yeah, it's a standard condition.
Yeah, I'm comfortable with that.
Okay,
This is not a standard. Thing about
any
It's
other,
a little wild.
any other comments, for anybody
You're
else?
welcome.
Basically, what we're doing is just putting lot lines on a map. Yep.
Yeah.
And we're not granting any approvals to do anything other than
Correct.
the lines.
If there are problems down the road and you grant approval and one of the lots doesn't have access, if they wanna do something with it, they gotta get access somewhere, somehow.
Yeah.
Or whatever.
I'll make a motion to grant the requested waivers.
Subject to our receiving information if need be down the road.
What Lou said.
Okay.
Is there a second? I'll second.
That means though, that we're just gonna put lot lines down?
Well, they're gonna make a case.
Yeah.
And their case ultimately is gonna be, we want to have this property subdivided into maybe three,
Total of 8, and we'll,
eight parcels. And yeah, I mean, we're not dealing with any construction, any sewage, any, where the well's gonna be, swimming pools, anything like that. In fact, if you read the environmental commission, and they want a lot of this to stay open, but that's down the road. Yeah, so we're basically dealing with just dividing this property into 8 lots as they requested, and we can certainly question. If there's no access, I don't know if at this point they're not developing anything, they're not asking for any changes other than putting lines that aren't there now. And for purposes of resolving issues, yeah.
And Lou, and have you, with all your years on this board, have you ever seen any application come in to subdivide a lot without at least some bare minimum information? Being that we just have lines on a piece of paper, basically.
Well,
What's been the
yeah, and for
experience?
here and in other boards I represent, there are applicants that come in. They don't wanna build anything, they just want to subdivide a piece of property, maybe down the road. The normal situation out here would be to sell, I get a subdivision, I sell it to a developer and I'm happy and he's happy. Yes, I've seen people come in with, they just wanna divvy up lots, and usually they're building lots. This is different, in a way, this is easier in that sense, because we don't have to worry about road connections, driveways, landscaping, trees, they're not doing any of that. So, yeah, this is not run of the mill, but it's within our bailiwick.
And Mark, I know that people have come in specifically when the 10-acre zoning was enacted and before it actually was enforced. There were people who were dividing their property,
Dropping pieces off.
yeah, into 5 acre parcels. So I know that happened. If they never did anything in those 5 acre parcels, that essentially the approval would be granted, it's abandoned.
So the lines are based on what?
Lines are based on what people want to put down.
They want, they're gonna tell us what they wanna do, how they wanna do it, show us these things, and. If it makes sense, and if it doesn't, involve anything that's gonna hurt Bernardsville, which. I can't see, but if they, so it's basically, it's their ballgame, they're gonna tell us what they wanna do, we listen, we ask questions. And when all is said and done, the land's gonna look the same now, or, the way it looks now is gonna look the same way if we grant the subdivision. Because they can't develop, they don't want to develop it, so it's gonna look the same, it's just gonna be divvied up legally, certain family members.
And we are gonna put controls in there. So that it cannot be developed until the commercial concern goes away. In which case, then the stuff goes to the planning board, but it still has to go to a board. In order to any further subdivision. And that's what's important. I don't want to just grant something and have it be acceptable and nobody ever has to come back to any board and just do whatever they want. Wrong answer.
Yeah, or if someone wants to build a non-residential structure down here, they have to, which is not permitted, they have to come here, which. So it might be a heavy lift, but
So
we'll see.
the point is that we're left with lot lines out,
That's it.
but you can't do anything with them without coming back to a board.
If we grant it, if we haven't heard it.
Yeah.
If we grant it.
And so without the subdivision information that Bob is recommending, and I understand why it's terribly important. But if you can't subdivide it, if you can't do things, then we're relatively protected in just dropping lots.
Yeah.
And that's what I'm hearing. So we grant these waivers and it's been moved and seconded.
Okay.
All in favor of granting the waivers? Opposed? Okay, so the application is complete, and now we can hear it.
Susan, what is your game plan tonight in terms of witnesses?
I have Mr. Schumer. And I also have, environmental consultants here if we need them, but I think.
No planner, yeah.
No planner, no,
I think,
Sean Moronsky
Yeah,
is our planner.
so he's not here tonight.
He is not here, he is not available this evening.
Okay, so it's gonna be Rusty and
And then if we need, which I'm hoping we don't, for their sakes, and mine, and yours. But I have, Francie Stella from my office, who's an environmental attorney, and Joe Sorgi, from Verdontis, who, are, available to testify that any of the, issues concerning any of the environmental questions that may be raised, and, with regard to the factory, if there's any questions about that.
And the normal rules apply, your witness testifies, the board asks questions. The public can ask questions of the witness
Regarding his testimony.
regarding his testimony, and then we move on. So,
Correct.
okay. Okay. Rusty, you're still under oath.
Yes, sir.
Okay, under oath, so, we did did we qualify me? Yes, I thought you did. Okay, great.
Not under him.
Yeah.
Yeah, so, what I'd like to have Mr. Schomer do is, just describe using some of the plans and the very nice aerial photo that is up on the screen now, go through some of the existing conditions and then, or the relevant existing conditions, and then discuss, the existing physical characteristics, and then what we're proposing to do in terms of the lot lines.
And if you use if you have any exhibits that we don't have, let us know so we can mark them, otherwise we're gonna assume we have.
Yeah, I think you should have everything except what's up.
Actually, you have this.
We have them.
You have that.
Oh, that's the one, okay, that's the one without the proposed lot lines. I see the blue lines and I think it's.
Yeah.
Yeah, okay, so we will have that shown. I think we did see it briefly, and so we will submit that to Ms. Florida.
Okay. All right.
So Rusty, just go through, as I noted, the
Yeah.
existing conditions, the location, the lot sizes and layout, the zone, the access ways, which the property does front on Minebrook Road, which is also known as 202, and what's the name, Meeker Road, and Hill Road.
Okay.
And Quarry Road. So this-
Right.
All right, so just kind of take the board through this then, with all of those
Okay.
queries in mind.
Sure. So what I have on the screen is a plan that was submitted, so you should have this. And it's an aerial photograph. It's entitled Aerial Map with Photo Locations dated February 21, 2024. Was submitted with the subdivision plans. And so using this, and I'm gonna zoom in because
So who prepared this?
I can't see this that well.
So this is an aerial photograph. that you
It's an aerial
obtained.
photograph that we obtained, and then we overlaid information from the survey of the property to show the properties. So let me just kind of go through a description of the properties, and I'll kind of start at bigger scale, and then I'll zoom in as we go along. So just for orientation, and before I do that, this contains also a number of photographs which are keyed into numbers in the yellow circles here. We can look at any of those, but if you have the map and you've had an opportunity to look at it, it does give you a pretty good sense of what the property looks like today. And that is a lot of open space, open fields, farmland is what you see largely from the exterior. Number of the photographs are keyed into where the glitter factory is, and we can look at those as we go along if you like. So, in big picture, this property is 215 acres, just over 215 acres. As you can see here, and just for orientation, north is, I'll just scroll down, you can see the north arrow is up here. So north is up the page. North is going up the page. And Route 202 or Minebrook Road runs along the top of the page, if you will, if you could follow kind of where I'm showing with the cursor. I always think of 202 running north and south. It actually kind of runs a little more east-west here. Route 202 is at the top of the page. As Susan said, the property is bisected by the railroad, new NJDOT, Department of Transportation Railroad, formerly the Erie-Lackawanna Railroad, runs through the property in this sort of circuitous manner, if you will, through the middle of the property. And then the rest of the property is to the south of that. So we really have two parcels that make up the total 215 acres. This northern parcel, which fronts on Minebrook Road, and it also fronts on Meeker Road over here on the left, or sort of the west side. That property is 124.5 acres. It is block 96 lot 2, and that is the entirety of this northern parcel bounded by the railroad and Route 202 and Meeker Road to the left, and actually goes up to Quarry Road up to the very top there. So that is one parcel on the north side of the railroad tracks, 124.5 acres. On the south side of the railroad tracks is a separate block and lot. It is block 100, lot 1. And that is the entirety of this portion here on the southern side of the railroad, all of this, and that is 90.67 acres. So that's sort of in total, that's where we get the 215 acres between 124.5 and the 90.7 acres on the south side here. So let's look a little closer. And, oh, I'm sorry, yes, so, and Pill Hill Road, has frontage on Pill Hill Road down here on the south side, so that runs along the southerly border, so we have frontage on Pill Hill Road down here. So as you can see, it has significant frontage on a number of streets, Pill Hill on the south, Meeker on the west, Minebrook on the northwest, and a little bit on Quarry up to the northeast. So let's take a little closer look at these lots and see what's going on here. So looking at this block 96 lot 2 with 124.5 acre parcel. Okay, what we see is that, and where the pictures are, we can look at those if we like, but in the center, basically in the center of the property is what's going to be referred to as the glitter factory. There is a factory building. There are some other accessory structures. There is and we can zoom in and look at these. So the main factory building. There's an office garage over here with an apartment. There's a building called the Creamery Building, one called the Granary Building. There is a main cow barn and a smaller cow barn and a horse barn. So those are the other accessory structures. Those are right in the vicinity of the factory. So we have the factory operations, and there's also the farming operations. So some of these structures are associated with the Meadowbrook farm activities. If we look a little bit to the west of the glitter factory, which is kind of in the center, we have a more residential use. So this is a dwelling for Roberta Ruckman. And clustered in this area are 3 other accessory residential structures. There's a guest cottage. There is a what's called a farmer cottage over here, and then there is a garden cottage. So, and we've identified these on the subdivision plans. But we've got the main house, 3 other accessory residential structures which are existing. And a number of other accessory structures. There's a greenhouse, there's a couple of chicken houses. There's a goose house, there's 3 garages on the property, and a pool house toward the back of the property. So those are really, again, clustered in the area of this particular residential use, sort of to the west side of the glitter factory. If we move a little bit to the east side of the glitter factory over here, then we're looking at where there's another main dwelling, and this is the residence of Peter Rushman, and associated and around there is a pool and a deck. There's one other accessory residence on the property, and that's actually called the Pond Cottage, which is up further to the north and east. And then around the dwelling is a workshop. Nearby is a workshop, a tool shed, a feed house, a calf barn up a little bit above it. There are a number of small sheds and a barn in the back and a roofed area, which is over here. So again, that is really the activities that are taking place on around that residential structure. Surrounding all of these improvements, and again, you've got the glitter factory in the middle and a couple of residential uses on either side. Surrounding all of these, and just to back out again, so those are this kind of in the center. Surrounding all of that is active farmland with mostly open fields and some wooded areas. So there, if you look at the aerial, you can see all of this area to the west is largely open fields. You can see where some of the wooded areas are at the perimeter, along a driveway, along some tree rows, which you typically see with farming activities. Certainly some trees are in the house areas, some other areas where there's some trees, but a lot of open space and a lot of open farmland. So that's what you see on this 124.5 acre parcel on the north of the railroad track. Looking at block 100, lot 1, it contains basically open fields associated with the farm use and some areas of woodlands. There's no structures, no homes, no buildings. And I should have mentioned, actually, going back to the north side, there's a barn on the west side over there is a barn, commonly called the White Barn. And then there is a small shed over near one of the fields. It's called the field tool house, but it's a shed. But there are, going back to the south side though, on block 100, lot 1, there's no structures on this side of the railroad tracks. This is all open fields, again, associated largely with the farm use. To the west, as Susan pointed out, I mentioned Roberta Rushman's house and Peter Rushman's house to the west, and just off-site, but adjacent to this lot, on a separate lot, which is lot 1.01, is the residence of the third sibling, Henry Rushman. So his house is over here. This tract is already subdivided out. It's not part of this application, but just kind of pointing out where the siblings' dwellings are that Susan indicated are on or near the property. But the lot that is part of this subdivision is this lot. You can see some wooded areas, but most of it is being open field. So that's the entirety of the property, the 215 acres. The entire property is in the R1A residential zone, which is largely intended for single-family residential use. Minimum lot size of just over 3 acres, 137,500 square foot is the minimum lot size in the R1A zone. So basically, we call it a 3-acre zone. And of course, these lots are very large. The property is really kind of a valley. The Mine Brook runs through the property from north to south. So starting at the north end, Mine Brook enters the property, runs through the site, kind of through the middle of the property, and then exits the property on the south end. And that's obviously flowing along through the lowest elevations of the property, and similar to where the railroad is. So the railroad and the Mine Brook follow something of the same pattern in terms of where they're located through the center of the property. So then if we go from this low point in the valley, and the property slopes up towards Mine Brook Road, Route 202, and then it slopes up toward Pill Hill Road and to the east, towards adjacent properties on the east side of the property. So it's high on the sort of on the bottom of the page, higher on the top of the page near Route 202, and as I say, really sort of a valley running with Mine Brook running through the center of this property. We do show on the subdivision plans that were submitted, plans, I didn't put them on here because I was concerned about too many lines, but we do show a riparian zone associated with the Mine Brook. So DEP would assign a riparian zone to the stream. We show that at 150 feet and 300 feet, depending on where you are. One of Mr. Brightly's comments in his review memo talked about making some adjustments to that, and we did make those adjustments on the plans that were submitted. So we show that on the subdivision plans that hopefully all of you have. So there is a riparian zone along there. And the site does contain areas along the stream, primarily. It does contain areas of freshwater wetlands. And we've shown on the plans an assumed 150-foot wetland transition area. That's the maximum wetland transition area that the DEP would assign. The riparian zone and the freshwater wetlands that we show on the plans are what we've taken that have been mapped by the NJDEP under the NJGeoWeb information. So we've shown that consistent with what's mapped on the NJGeoWeb. We also show on the plans a floodplain associated with Mine Brook. And that is based on the FEMA flood mapping, and for the borough off of Mine Brook. We've looked at those, we've taken those into consideration. That's been part of what's gone into a study of this property that we've been working on literally for the past couple of years to look at how this property might be used and developed. Not that that's not what the application was proposing to develop it, but we've looked at it for what might happen. And that went to the purpose of how does this get divided to meet the requirements of the estate and was used for valuation purposes. I know that's not an issue that the board would get involved with, but I'm just explaining that we've looked at these environmental constraints, looking at the impacts on the property as to how that would impact the further use and development. We've visited the site on a number of occasions, looked at where many of these constraints are, and the mapping that we show on the plans, I think, is generally representative of where they are. We haven't done a specific on-site wetland delineation, but we have looked at areas and said this area would certainly be classified as a wetland. But having said that, there are areas outside of those environmentally constrained areas where looking at the lots that we'll look at in a second, you could put a house on each of the individual lots that we've shown here. And I know that's what Bob was concerned about, looking at the subdivision as is.
Yeah.
Could you support a house on here? And in my opinion, you can. And we'll look at lots more in a minute. We added to the plans, at Bob's suggestion, added information about the soils and the soils mapping. And in doing that, you can, what the soils mapping also indicates is the topography. What I can tell you is, I'm sure everybody's familiar with the site, been by it 100 or 1,000 times, but on the in the lower reaches closer to the stream, and this northern parcel is flatter through that area. So that the topography in this area is generally mild to somewhat moderate slopes. And those slopes are actually a little closer to Route 202. Through the center where the stream is, it's pretty flat. When we look at look at lot 100, lot 1, the southern parcel, that has that topography is moderate to somewhat steeply sloping. The soils classifications, which is a Chamonix, Mount Lucas, silt loam of 6 to 12%. And then in some areas, it indicates it goes up to 18%. So there are areas of some steep slopes, but nothing that we think is prohibitive in terms of use or development. So when we look at the lots, again, which we think are very oversized and not intended for development, but certainly they could support a dwelling. And I think to Bob's comments, we can be comfortable that we can provide that each of the lots that we show can support a dwelling. Not that that's what's proposed, but that it is a suitability question and a valid one. The property, as I mentioned, does have significant frontage on Route 202 and Pill Hill Road, as well as on Meeker Road. Primary access into this site. And again, really the uses are clustered in the center here, but there's a primary access coming in off of Minebrook Road, a driveway that comes in and provides access leading to the glitter factory and leading to the other uses, to the dwelling to the west, and the dwelling to the east, and the other structures. No changes proposed to the access. We're not proposing anything. There are, I should point out that because of the presence of the railroad, there are actually 2 permitted legitimate crossings of the railroad. One is sort of on the right side or more northerly side, and then one is further to the south and west. So there are two legitimate and permitted crossings of the railroad there. And that's really to access the farmland that's on the south side of the railroad. Because the facilities and structures are on the north side and there are simply, as I mentioned, just fields on the southern side. And then there are internal driveways, of course, to get access throughout the site. In terms of sewer and water, came up as a question. The properties are currently served by on-site septic systems and wells. And we've shown those on the plans to the greatest extent that we know where all of them are. But we do know that the existing dwelling, Roberta's property, Peter's property are served by individual wells and septic systems, which are in place. So those are functioning. The factory use has its own septic system, which we're planning to retain on its own lot that we'll look at more in a minute. But but all of those are in place, and I think it goes to demonstrate the suitability of the property to be able to support wells and septic systems for single family residential use for the zone. There was a question that came up, and Bob, you had raised it, about an Egipides permit, and there actually is a current an Egipides permit, New Jersey Pollutant Discharge Elimination System permit for the factory. Oh, there's two. Okay, there's two Egipides permits. Sorry, I'm corrected.
My experts.
Okay, all right. So those are in place and no changes proposed to those. That's simply because you have a commercial type use going through a septic system, but those are in, they're functioning, and those are no change proposed to that. But I know Bob had raised that question. As we've said and continue to say, that the goal is to keep all of this as is, keep it in its current condition, but really just to create some different parcels so that we can take care of the requirements of the will of the estate. What I'm going to go to next is another. I picked the right one. Yes. Okay. Another exhibit.
So you're gonna talk about the
proposed layout, and a little bit more about the lots as we've shown them. This exhibit you don't have, Lou. So
Yeah, so-
mark it,
so we need-
and I will be happy to forward it.
Mark this A1.
Okay.
This is the straight.
This is, and I'll tell you, this exhibit is entitled Aerial Map with Proposed Subdivision. And it's dated September 13, 2024.
Okay.
We prepared this one more recently for this presentation.
What was the date?
13, yes.
We can provide copies, trustees.
We will.
Today.
Yes, I'll email that to you.
Please, and yeah, and visual.
Okay, let me know how many hard copies you
And
want. It's really the same aerial that we were just looking at, but we've superimposed on here in blue are the proposed lot lines. So same orientation, same layout, Route 202 at the top, the railroad through the middle. So you can see the factory, the glitter factory use here. So let me just kind of briefly go through the various lots. So lot and these proposed lot numbers we've assigned, we think they make sense. We did make a correction to them or an adjustment to them for Bob's memo. He suggested changing lot numbers. And so we've done that on this exhibit and on the plans that you have.
And what were those? Are you gonna go through?
I'll talk about those, yes. So kind of starting from the left-hand side, the westerly side here, proposed lot 2.01 is this lot with frontage on Minebrook Road and frontage on Meeker Road. So this lot is 34.95 acres. It's open space. It does contain the white barn that I mentioned earlier, so that's down in this corner. And there's a shed that I mentioned on the property as well. But basically it's farmland, almost 35 acres basically. The Mine Brook runs through here. If we look at the subdivision map, which I have, if we wanted to look at individual sheets, but if we look at that, we do see the areas in the low part by the brook, which contain the bulk of the environmental constraints. There is an area to the west and an area to the north, which is not really encumbered. And in my view, there's sufficient space in there to put a single family home compliant with the requirements, particularly closer to Mine Brook Road. You're well uphill, you'd be outside of floodplains and away from those areas of the greatest constraints, which are frankly associated right next to the Mine Brook itself. Moving to the right, proposed lot 2.02, 35.6 acres. This is the one that I mentioned, contains the single family dwelling, the Roberta Rushman's house, and the other structures that I mentioned here. Also contains farmland. There's a farm pond over there. So that would be a 35+ acre lot. Again, frontage on Route 202, and would house those structures and really no things to happen. Lot 2.03 and 2.04 were the ones actually we switched. We had a number the other way around, but per Bob's suggestion, we changed them. So lot 2.03 would be where the glitter factory is. It's a 6.5 acre lot. We show it with a staff leading to Mine Brook Road, so it has frontage and access onto Mine Brook Road, and that would be where the existing driveway is. We wanted to put the factory on a separate lot so that that glitter factory use would be separated and be on its own lot. And so that was how this was done. The shape of these, if we were doing a normal subdivision for single family homes with developments, you wouldn't see these kinds of lot lines. It was really constructed to accommodate the existing features on the site. So, for example, the glitter factory, there's an area which has a parking area which is used where trucks come in. We want to have access, and we wanted to retain that use and activity on that lot where the glitter factory currently exists. So that's why you see some different shaped lot lines in this area. And then we went up between some of the buildings, again, to try to separate those activities which are more associated with the glitter factory use to stay on that. At 6.5 acres, it's more than twice the size of the minimum lot size required in the zone. Well, when we talk about variances, what you will hear is that variances are not being requested because we're building anything new. The variances are associated with existing buildings and structures, and because we're creating a new lot line. So when we put a lot line, for example, on this left side or the westerly side of the factory building, or we put one down to keep the factory use on one lot and try to create the other uses on the other lot, the lot line ends up being close to some buildings. So we're seeking setback variances to allow those existing structures to remain. And it's really a setback to the new lot line. So that's going to be the driver and the reasons for when you hear variances, and you'll hear it sounds like a lot of variances. Well, because there's a number of structures, and again, it's simply because of the proximity of existing structures to new lot lines being created, not to build any new buildings close to a lot line. All of this is you can see here, and of course, when we zoom out, you can see it's very internal. So this is nothing that is apparent. I know, I'm sure for all of you and for me as well, you drive by this property and you see fields. You don't see a factory. You don't see really much activity. You see open fields and a lot of open space. And that the goal is to keep that, not change that. But with the activity really being centered in the middle, when we do create a lot line, that will
you will hear about variances for those. So that's lot 2.03. Lot 2.04 was a separate, primarily vacant, really a vacant lot. 6 acres, so it's almost twice the size of the minimum lot size required for the zone. Has frontage on Brook Road. When we looked at these, we certainly had to make sure that every lot had frontage and access to a public street in order to meet the statutory requirement for subdivisions and under the municipal land use law. But this is really farmland today. Lot 2.05 is the rest of this northern parcel, which goes all the way up, and contains 41.4 acres. And this is where Peter Rushton's house is located that I pointed out in the other exhibit, and facilities, right, and structures and activities right there. And
There's farm related?
they're farm-related structures. It had one other cottage and other farming activities on that lot, but that's a 41-acre parcel. That would be created. So those are the lots on the northern side of the railroad. And then if we go to the southern side of the railroad, there are 3 lots that are created. Lot 1.03. Which has frontage, a little bit of frontage on Meeker Road and frontage on Pill Hill Road. Lot 1.03 is just over 24 acres, and as you can see, it is farmland and woodland in the center portion. Moving to the little bit to the north and east. The next lot is proposed lot 1.04. That's 26.5 acres. Again, open field farmland with some woodlands. And then proposed lot 1.05, which is just over 40 acres. And that's the balance of the property on the southern side of the railroad. And that is, as you can see from the picture, it is really farmland for the most part, with some perimeter areas of some wood and some tree lines.
Does that lot also have access on Hill Hill?
It is, thank you. It has frontage on Pill Hill Road.
Just in that
In this portion here, correct. So, so those are the lots that we're proposing, the areas and some of the features that are situated on those. The environmental constraints we took into consideration. On the southern side of the railroad, we don't really have much of a concern with floodplain or other significant environmental features. The steep slopes are not prohibitively steep. As I mentioned earlier, and if you look at the soils classifications, that's generally 6 to 12%, with some up to 18% at the border is how they're classified. And there may be some areas of steeper slopes, but not slopes that would be prohibitive, wherein you could not place a single family dwelling on any of these lots. All of these lots, in my opinion, are suitable for construction of a single family dwelling, which goes to Bob's concern, which is valid, that you want to make sure the lots you're creating are suitable for the zone purpose. And again, not that we're proposing that, but you as the board want to have that comfort. We do show on the subdivision plan, and I didn't plot it on here, but I can tell you that we do show on the plans a number of easements, because we have current existing activities on these different properties, and we want to maintain those activities. We want the owners to be able to cross one property over another property to get to properties on the other side of the railroad, for example. There are easements to allow crossing, for example, of say lot 2.05. To get across, remember I mentioned that there are a couple of railroad crossings. We can't cross the railroad anywhere. We're limited to 2 spots. So one of them is in this location here. And there's a driveway that leads across there. In order to cross there, to get to farmland on the other side, we would need an easement to cross lot 2.05. Similarly, we want to have access along an existing farm road here. to get to other parts of, say, lot 2.02. So there's an easement to allow that to occur. The easements are to really needed and necessary and desirable to maintain the existing activities on the site. To maintain the farming activities, we need to get to the field that's on the other side of the railroad, for example, but we need to cross somebody else's property. This is again, is once they're divided up and they're in different owners. So that's the reason for the easements that we show on the subdivision plans. And I have the subdivision plans if we want to look at those in more detail. And we recognize that there are utilities that cross properties and the plan is that there would be some common cross access and utility easements that would have to be put into place for the lot configuration. And that's understood again to maintain the existing conditions on the site as you see here today and as I've described. Since there's no, normally doing subdivisions, I'm talking about, what we're gonna build and stormwater management and things like that, but that doesn't apply here. We're not doing anything. We're not building anything. So that makes that part a little simpler. I think that's really most of what I had to go through.
Yeah,
Susan, if you
you
have some
covered
questions that
everything
I
in terms
missed,
of-
or certainly,
You covered everything.
Board
I was
questions.
gonna ask you about the utility easements, but you just covered that. Access you covered, yeah, I think we're good.
So,
So we would open it up to the board for questions.
I'm sorry, I'll put it stall off.
Yeah, I probably asked several questions, but you ended on the stormwater matter. So it's a good question. How do we, any development on here? It's gonna be cumulative. How are you gonna allocate the impervious surface, the disturbance? The first property that gets built is probably gonna disturb an acre and, or maybe less, and anything else is gonna be a major development. So how do you anticipate allocating? Are they all gonna be considered majors? Any houses built on here?
we have no, as we've said, we have no plans for doing anything, and I know you have to think about what's gonna happen in the future. We have no plans for doing anything, so I can't predict.
So if a house,
Yeah,
2 years from now, he comes in and want to build a house on lot 105. They can't build a house on lot 105 until the letter of tax, is that, so that's certain, can't, I'm speaking here.
Yeah. If I can interrupt, I think, Trent, do you wanna? I mean, I think once it's subdivided, it's subdivided. So I think, correct me
Somebody
if I'm
could build
wrong,
a house.
but it's no longer one parcel. It's no longer one property. It's a separate lot. So, and if they have to go through, if there's either a subdivision where it would come before the board, or if it's just one house, it would be going to, just let me finish. If it would be one house, and it would go for all the building permit and all of those reviews, and I would assume that you would be reviewing it as well. So that's a decision in the future. Because
I don't
this
want
is,
to talk about what going to a future board. My question is, this property is one property. You have 3 lots on one side. If someone builds a house on lot 105, they could conceivably stay under the threshold for a major development. The other 2 lots coming on are also, are gonna now be kicked into major developments because it's cumulative over the whole property. So I'm asking the question if there's any thoughts on how it's gonna be allocated, or is it just first come, first serve?
I think it depends on how you define property.
Well,
It's not combined anymore.
it doesn't matter for stormwater management purposes.
Francie's interest.
Well, if you don't wish that.
Yeah, I'm gonna have-
Down in a little while.
There's really no plan for allocating. So there's no plan for how it gets allocated. Somebody comes in to build on lot 1.05, they'll have to conform with the regulations in effect at that time.
which could be different. They
Could be
might,
different
they might
than
be
ours
subject to a different standard
That's right.
than a house on Longport.
Good, and the standards may well be different then than they are today, so they'll be subject to the standards in effect at the time. And if then if future development requires some additional requirement, they'll have to deal with that.
You understand that it's cumulative.
Yeah.
No, this is where my questions to start with were, and I think we need to build something into the resolution that controls it. I have one question.
They'll have to conform, yeah.
Will the property, once it's subdivided, stay in Bruce's name? Will each one of the 3 heirs get sold to lot, say, 2, 3, and how will title to the property?
Ownership will change because they'll go to the 3 heirs, so the lots will be in different names.
So Rusty, just to clarify that then, we will be recording the plat, correct? And then we will also be issuing separate deeds for each of the lots. We're not gonna, each lot will have its own deed, and it will also be recorded as a subdivision plat.
As a major subdivision, we will have to have a final major subdivision map that gets recorded. But the ownership will change because there'll be a new lot, and some may go to one person and some may go to another. But that's simply the ownership of those individual lots. Does that answer your question, sir?
I couldn't write that down. It wouldn't stay in the Meadowbrook estate.
Right.
It's split up amongst. the
Correct.
heirs.
That's correct.
So a couple of things come to mind. The railroad crossings that are currently permitted by New Jersey Transit. Does New Jersey Transit have to be informed of all of this subdivision activity?
We did notice them for the hearing, but you're asking if there's something separate?
Yeah, since there are crossings, unsecured crossings, whatever the term is, they're open crossings, there are no gates there.
It's certainly something that we can look into. We can confirm or, or confirm with them.
Yeah, I think we need to confirm with them what needs to happen, if anything, with those crossings. I think that's an important conversation.
This subdivision will require NJDOT approval.
Correct.
That, so.
Yeah, but I think,
This is probably something that they would look at.
I think we need to ask the question before NJ Transit looks to approve things, because don't rubber stamp stuff. I don't trust them. They have no money.
They will comment on access for lots.
Yeah.
They do, I'm sorry, they do or they don't?
I anticipate that they will.
Yes.
Second thing, comes to mind, the driveway, the existing driveway off of 202 that you're showing, whatever, the glitter factory lot. Is that driveway completely contained within the glitter factory lot?
Yes, and there would be an easement over that driveway for access to the other lots. Yeah, that's indicated on the subdivision plans.
Okay. Next question, was the prior resolution that permitted modification to Peter Russian's house? Did that have any effect on this subdivision work that you're doing?
Now, I know there was an addition to the house, and that was completed. There was some septic work that was done, that's completed. But it doesn't affect this subdivision.
Okay. Next question, there's a whole bunch of what look like trailers. Up from the Peter Rushman house, yeah, up in that area.
Yeah.
What is that use?
To my knowledge, it's associated with the farm activities. But specifically, I'd have to find out further about that to
Okay.
figure that out.
And it's probably within the riparian buffer?
There are existing activities, and there's no question there are existing activities occurring in the riparian buffer. Which, existing activities are permitted. I mean, the DEP recognizes that you have a riparian zone and there's activities currently going on there. But if you want to build something new or something like that, that would require permits. But existing activities, are ongoing. There's no change to it.
Any soil contamination from those existing activities?
I can't answer that. I don't know enough. It's not my
Let's
expertise.
get that answered.
Okay.
I've noted that and we'll look into that.
Okay. Those are my initial questions.
Can I ask you one?
Sure.
Rusty, given the size of the property, the entire property. I'm assuming that there would be ways to modify the lot lines to avoid several of the dimensional variances. Could that happen? So there's not side yard setbacks.
What you find is most of them who are associated in that area, I mentioned where there's clusters of buildings around the factory and so we want to separate the factory onto its own lot.
Right, and those lines be adjusted to not require.
We've looked at that, we've tried to minimize it as much as possible and try to be consistent and where it's going between buildings to try to provide at least some minimum setbacks, right?
All right.
Any other questions from board members? Yeah.
Could you explain the rationale, you spoke of all large lots, which they're all, 35 acres, or whatever, then you spoke specifically of the 6 acre water lot. But why then, is that additional 6 acre lot, why would that, to minimize, I'm assuming more state land?
Yes, it really had to go with, again, we looked at how they get divided up and kind of what goes where and.
It just wasn't consistent with.
Because that was smaller, I understand, yes, but it's also on the other side of the factory lot, so there's the factory lot has the staff that goes up to 202, and then we needed to create another parcel, so that ended up having to be a separate parcel.
And the other question is, when you said that there's going to be, if, as a continuous shared use, so the farm can continue itself. I don't know, is there any, shared water right that can be built in other words, and also the shared use of the pond? I'm not sure how your farm functions, but it's, let's say someone up on the north here is farming, you don't need access to the pond, and I don't.
Right.
So is that something that's also being
So
discussed?
that would have to be into any easement documents between the properties.
Right.
And just go back to the New Jersey Transit crossings, are those, could be set in stone, or is there the possibility? If needed, could there be an extra one, say between 205 and 105 for the north? Or is there there's no way that there's two? And that's-
Yeah, we're all.
New Jersey Transit.
Yeah.
Yeah, all the lawyers and
We won't be here,
We're all keeping.
If that were possible, then it was, no, I don't mean to be flip. No,
Yeah.
it's very difficult to get the fact that we have these two and to be able to retain these two is, we don't see the ability to gain any new ones.
And just to supplement that, most of the time, if they do give an access, it's a license for a year or two. Revocable.
So to that point then, so the lot 105, the intended access could only be from Philadelphia. And you have a long driveway.
Yes, that's correct. It's only frontages on Philville.
All right.
Is there anything in that license that causes us to terminate?
These are not licenses. These are permitted crossings. Yeah, I think this is saying, if you got a new one, when New Jersey Transit issues them today, they just issue like temporary licenses, revocable licenses, but these are permitted. I have to read the easement language, but they've been in place for many years and are permitted to stay.
Interesting.
So my question is that if one of the lots becomes now a residential lot, it's no longer a farm. Does that crossing go away?
I'm not sure we'd have to. look at the-
Yeah, I
That's
think-
why.
we can
there's
check the
a
easement language.
transit.
Yeah,
Yeah, I think that's something we'll have to look at.
Yeah.
My understanding is that those crossings have been there for 81 years.
Probably, but
Or-
as
and-
soon as
and-
you change the land.
Yes.
use,
Yeah,
They may no longer be allowed,
yeah,
so.
no, I understand that.
Your
We'll
New
look at
Jersey
that.
Transit on that one.
Yep, got it, understood.
So the easement that's shown on your map that provides access across the one crossing to lot 105, is that easement for farming activities,
yes,
not for future resident to come
Correct,
off
no.
Lime Brook and drive to.
the intent, we weren't thinking of, for access for residential uses or anything like that, it was to maintain the existing access to get across to be able to farm that other parcel.
So any future development on the Phil Hill properties without access for either Phil Hill or New Jersey.
Correct.
And my guess is once New Jersey Transit hears about what's going on, they would say, okay, so in the future it would have to be secured. You can't use it anymore. I would expect.
Yes.
That's why they need to ask the question now.
I have one more question. Will it maintain the farm? That was the subject.
That's the intent, yes.
Let me follow up on Chick's point. I'm assuming both of his properties are farmed in assessment. And I know in the old days, you needed at least 5 acres of active farm, or the 2 of those lots are 6.5 acres. Are they gonna be, I guess, so they're gonna be qualified for farmland? The lot with the glitter factory, is that gonna have 5 active acres of farmland? Otherwise, you might get a little rollback on that lot, rollback tax.
Sort of not our purview,
No, but I just wanted to give that.
I would expect that it's already assessed for commercial by tax, for the tax purposes.
The small syntax a lot, the land, the other that's.
All right, so this is about something.
Yeah.
But I just want to be satisfied.
Yeah, but as, tax assessor looks at things and says, okay, this much is residential, this much is business, and the rest is farmland. My guess is there's probably already a commercial component right there, but that's a tax problem, not ours.
No, I understand.
Describe the land that, what's the topography, because, we just have a lot of paper. Could you describe the topography of that top right lot? Is it similar to that land by the subdivision there that, where you just took away? See that land there? I believe.
So this is-
Flat, what is that land like? Is it slope? Is it a beautiful flat field? I don't know.
It's sloping, the high point is to the right side here, so the high point is over on the right side, as we look at the plan, or sort of the eastern side, and then it slopes down toward the railroad.
So that's all down there.
It's, yeah, and it's beautiful. We could, in fact, I have a picture of it if you'd like to see it.
You have, is there a drawing that has
There's
the
a pic-
elevations?
No, we don't have topography on the plans, but the earlier exhibit that I mentioned that has the photographs, if you look at that, there's a photograph standing near the crossing, looking up towards that area. I don't know the number of it, but it's on that exhibit that you have there.
It would make sense that elevation is required to the property.
It's in here going up.
I'm sorry, set,
Does it make sense that it designate
Number 12.
elevations at the corners of the properties, since we don't have a property?
I'm not sure what you mean by designate elevation.
Tell us what the elevation above sea level is.
Oh, okay.
Each one of the properties.
Oh, I'd have to get that information, but I could try to get that, yeah. So you have some.
Some basis for.
Okay, yeah, we could try to get that.
Yeah. Other questions from the board at this time? All right, I see we're gonna take a 10-minute recess. Bathroom break, which we've been going for 2 hours. And then we'll come back with follow-up questions. record? Okay, cool. Bob, you said you have.
Yes. Well, I wanted to ask a question regarding the various structures, if they know which ones have plumbing facilities and where the plans do show some septic systems. For example, on lot, I think it's 203 now. There's an office garage. It looks like they show a line coming out of there with an S on it. And it goes through the septic system that's on lot 205. So. I don't know how many other systems are like that, and how many of the other structures have. Septic systems that, you know, require across.
So I guess the question is, are all structures that have the requirement of wastewater disposal identified? That's number one. And number two, have you identified where the septic systems are for each one of those structures?
So we've shown, and the latest plans have been updated, excuse me, with some additional information that we've received on septic. So we do show septic systems on the lots, and really we're really looking at 3 areas. So for
My question was
Yeah.
really a yes or no question.
okay, oh, I'm sorry. Well, we show the septic systems on the properties. We show sewer lines and tanks on the properties. I don't have an inventory of which one each, has a sink or a bathroom. But we know that, for example, the factory goes to a septic system, which consists of tanks and then is pumped up to it.
Okay, the answer is no.
Okay. I'm not sure
Okay,
that-
so solve that one.
Okay, so you're looking for,
All structures that have the requirement for wastewater disposal
okay,
and where the septic systems are for each one of those structures.
okay, all right.
Because you're gonna need easements if they cross property lines.
Right. Which I indicated earlier, we expect there are gonna be some cross access and utility easement, but we'll look into that one.
Okay,
Yeah. and
That's all
make
there
sure-
is?
Those are. You asked the question perfectly.
Okay. Any other questions from the board or profession? Do we have questions from the public on this opinion?
No question.
Please come up and identify yourself.
I'd like to swear myself in.
I'll swear you.
There, no testimony. This is question on testimony for Mr. Schumer only.
You were not doing testimony in, just questions only.
Of this witness.
Of this witness.
At the end of the hearing, which is not gonna be tonight, members of the public can comment for or against, give some testimony, but not now. It's too early.
Okay, I would just ask you, you gave a description of the land.
Hold on, please identify yourself.
Oh, Henry Rushman, neighbor of, and owner of probably 1/3 of what's left of the estate. And,
Okay.
I live at 261 Pill Hill Road.
That little corner up on the lower right,
Yes.
lower left hand corner.
And that description that they gave is totally wrong also.
Question for Mr.
Oh,
Schumer.
where did you get the information for most of your testimony, Gary?
A review, well, look. Several areas, our study of the property, if you have a specific question,
Yes,
one thing,
the
okay.
compass headings you gave are totally wrong.
Okay,
You mentioned south and west and confused most of them. For example, the Mine Brook Road, the Mine Brook doesn't go north and south. Or does it?
well, if you recall earlier,
What you said was wrong.
Let me answer, Mr. Rudd.
That's the question.
Okay, my question is that I don't think you looked at the real facts when you gave this demonstration, and I'll give my testimony later, I guess.
thank you.
Okay, question.
Thank you.
Would you like to finish answering the question?
That's okay.
Okay. Are there any other questions from the public for this witness? Okay. Well, somebody's coming in. Okay. Come on up.
Can I stand on the X? Okay, let's. Okay, yeah, sure. Carrie Hazelton, 397 Minebrook Road. I'm sorry, I'm looking through my notes, trying desperately to find the name of the particular type of permit that had to do with some kind of discharge of wastewater that was associated with, and it was
Nigipides.
the Nigipides.
Yeah.
Exactly. And I had trouble spelling it and now I can't find
Just
what
make
it
it
says.
sound.
So yes, so I just wanted to ask for a little more detail on that. And, you know, is that what that's associated with it? Is it part of the factory or?
Yes, the New Jersey Pollutant Discharge Elimination System. NJPDES, Nigipides.
Nigipides.
It's actually called Nigipides. Is a permit issued by DEP for discharge of waste to, in this case, it's considered groundwater because it goes into the ground. The septic effluent goes into the ground. So it's a permit issued by DEP, and in this case deals with non-residential uses. So that's what it's about for the factory.
So it's going into the septic system for the factory?
Yes,
Not directly into the mine?
correct.
I'm sure they wouldn't allow it. All right, thank you very much.
Sure.
Mr. Chair, can I ask this follow-up question regarding that?
Sure.
Is it possible to get a calculation of various uses, what the total existing sewer qualities?
We could estimate that, yeah.
Because I guess if you have a T1 approval level, is that gonna go away? Once you break this track up, I guess you're not gonna be over 2,000 gallons in any one.
Correct.
We haven't heard any comments from the health department on this.
We have not, no.
Has it been sent to them for review? I would assume Denise, you would.
Yes.
Okay.
I mean, they might be able to clarify a lot of the questions.
Okay. Anything else? Okay. We are at 10 o'clock now. I would like to continue this at the next meeting rather than continuing this application. We have other business.
Interesting. That's fine. That's exactly that.
So, given that, I'm gonna add, let's see, 7 is already spoken for, right? Denise?
Yes, let me just. We went over that.
Conditions and things that we want to follow up on. Yeah, that's actually what I do.
Yeah,
Yeah.
yeah, we have signed her for the status.
Okay. So this is the 21st word,
21st of
October 21st?
October 21st?
Yeah. Yes, you know, generally in these instances, I ask because applicants can have issues where they can't get to a meeting. So generally what I like to do is adjourn it to October 7th without need for further notice. And then at the October 7th meeting, if we can't get reached, I mean, we'll know ahead of time, then you would just make an announcement at the October 7th meeting that it's being adjourned without need for further notice to the 21st.
But we're not gonna hear it on the 7th.
You're not, okay, then that answers the question. So if no one I mean, if the two applications that you have on don't proceed, then you just won't have a meeting.
It's unlikely because they've already noticed for the 7th.
Okay, understood. Been doing this a really long time as we all, and it does happen where where I said, right, for many of us, and it does happen where, but I respect your comment, so we'll adjourn without need for further notice to the 21st of October.
Yes, if that date works for you. Okay, cool. Thank you.
Sign, it's just one, that's fine.
How complicated is it?
Well, there's more to it. There's no other note on the house application, right? That's gonna be the cost.
Okay.
And all of it is, you know, where to do.
Yeah.
Yeah, I'm not worried about it.
Yeah, it's all your.
Oh.
It's, there are quarters
What's the issue about that one? Because I haven't seen any of the application.
It's not something good or.
Yeah, work out.
Mr. Chairman, it's an addition to an existing residence. See that?
And it's a deed.
So the agenda typo then?
Yeah.
Okay, all right. So we could get to you.
Oh, wonderful, wonderful, okay, so we're gonna adjourn without need for further notice
Yeah.
to October
Is that
7th.
enough time for us to agree to get
You
your?
would be the second application.
That's fine, as long as we'd like to try to keep moving.
I understand.
Yeah, no, we appreciate it.
Okay,
Thank you very much.
all right, Carrie, this application we carried to October 7th. No further notice. It will be the second application heard. Okay.
I'm too over.
Oh, Mr. Chairman, they're squaring the building.
They're what?
They're squaring off the roof one of it.
Okay, all right.
And there should be a report on.
I recall receiving something.
Yeah, they.
Okay. Thank you. Okay.
Thank you.
So now we go on to the bills.
Take care.
Thank you. Thank you.
Thank you.
See you on the 7th.
I'll see you on the 7th.
Thank you, everybody.
Say it, okay, all right.
Thank you.
All right.
I'd like to say good night to the board and thank you for looking into this so thoroughly. We owe our farm to the first 4 boards of adjustment that I personally was at to get the variance the way it is, which has protected us for 80, well,
A long time.
for all our life. And God bless you all.
Thank you. Thank you. Okay.
I'll make a motion to pay the bills.
Second.
Second. I'm sorry. Okay. Roll call, please.
Mr. Dela Russo,
Yes.
Mr. Greenbaum,
Yes.
Ms. Kramer,
Yes.
Mr. McDowell,
Yes.
Mr. Salyer,
Yes.
Mr. Trainer,
Yes.
Mr. Slocum,
Yes.
and Mr. Malillo.
Yes.
The motion carries.
Cool. You got your one.
No, I put in.
Yeah, no, geez, it needs, you guys are killing us. I think this direction.
Don't put that on the record. Okay, so pending applications, we have perennially pending public fines, which has been pending for what, 2 years? Lord knows what they do. Talking about Gonzalez application, they're gonna pull it.
Yes, so I spoke with the property owner. And she was upset with her professionals because apparently she had told them that she was withdrawing the application and nobody notified me. So I said to her, well, we need something in writing, so I'm waiting for that.
Okay.
She said it was becoming too complicated, so I think what they're going to do is instead of constructing a new dwelling, they're gonna make modification to the existing.
Damn, I thought you were considering a move.
Welcome to Burns.
Well,
Wait, that one we wanna see.
Cause you want a chair, right?
Yeah, that's right. Oh my God. Put me in. Oh, darn it.
You know what, they still may need variances.
Okay.
well, you never know, they may change their mind again.
You're irreplaceable, by the way.
No,
Just pinch hitting, that's it.
no. Not irreplaceable, nobody is irreplaceable. Nobody's irreplaceable. Okay, so Steinberg, we're hearing on the 7th. And,
Correct, that's it. So,
and this is, and this one is this any relation to, former speaker?
Oh, jeez.
I don't know.
Both variants related to construct an addition to the existing non-conforming dwelling. You got any comments on that one, John?
Which one is that?
Fenton and Post. Fenton?
Yes, we have reports, all those. There are reports.
Okay,
I would rather not comment on the record until they appear.
Yeah, well, and that one,
Sad.
yeah, the last one is still incomplete.
Yeah, I mean, the incompleteness items for the Cs are not usually the big issues, and I generally would say let's proceed with these. Subject to the concurrence of the board engineer, because, they're usually minor things. But it's up to the board.
are they
More
reports online
applications,
for
right, Ken?
leave schedule?
Yes, so just an FYI, as soon as applications come in, as soon as they send me the application, it's supposed to come with the digital, okay? If it doesn't, it's usually within a couple of days. They're on the website. So this application's been on the website since it was received in July. And then as reports are received, they're loaded into there.
Okay,
So yes,
So- so
whatever I've
John
got so
reports out.
far, yes. is in
okay,
there.
super.
Both. I think
So you can always have a
Yes,
sneak peek in
and Bob's
advance.
reports are there too. It's a great feature, a lot of towns are doing that now.
Yeah,
They're
yeah.
wonderful.
Okay,
Yeah, so you can always kind of, it's on here, but then you can also take a peek online and see what's
good deal.
in the application.
Anybody have anything else?
I like to say something when we're off the record.
That bad, not checking.
Yeah, it is.
Uh-oh.
I just felt, you
Wait till
gotta.
Why don't I make a motion to adjourn?
Go ahead, Eddie.
I make that motion to adjourn.
Second. There's 2
Okay.
seconds. Big one. All in favor?
Aye.